it's wonderful to talk about a successful piece of climate change litigation. I've given a few seminars this year on what makes for a successful climate change case, and it felt a little bit fraudulent because I didn't actually know at that stage. This was a very successful judicial review. As a result of it, there will be approximately 20 million fewer units made available through the government auctions over the next 5 years. And just as importantly, the price of ETS units on the secondary market was down to $35 before the judgment came out. It then went up to about $45 and then went up to over $60 when the cabinet reconsidered the issue and decided to follow what the commission had recommended. So it is today twice as expensive to emit greenhouse gases in covered sectors than it was before we brought the litigation. So that's a wonderful result. It was also within 10 weeks of filing the statement of claim. The Minister and Crown Law Office rolled over after about 6 weeks. We had 2 weeks of negotiating a joint memorandum to explain it all to the court. We then very quickly got the High Court decision, and then much faster than we were expecting, Cabinet were able to reconsider it and confirm that they were following the Commission's advice. So I think everyone involved is very chuffed and can rightly feel proud that it's not only one of the most successful bits of climate change judicial review, but it's also one of the most successful bits of judicial review in New Zealand's legal history. So I could talk a little bit about the emissions trading scheme, but I don't think I will, for the reason that we're a bit limited in time, but also there's a seminar next week, next Tuesday, with myself and also Ian Parry, who's a visitor from the IMF, and we're going to talk about how the ETS works and what the current reform issues are. So I'll leave that as a teaser for people to join up and go along to that. It's been advertised through our newsletter, so you should be able to find the links to join up to that. There are also submissions due on a current round of ETS reform on the treatment of forestry. They're due on 11 August. LCANZI will, of course, be making a submission, but anyone else who's interested should. So what I thought I'd talk about instead is reflections on what made this a successful judicial review, and there are 6 things that stood out to me. The first is that the decision made by Cabinet was immediately scrutinised by journalists, in particular Mark Dowder, and by interested climate scientists, in particular Christina Hood. So immediately there was commentary out there saying, the minister recommended that the commission be followed. The commission's been set up to give independent advice and Cabinet's overruled it. What's going on? So there was, it wasn't that we were the first ones breaking the soil by any means. It was already on people's radar that there was something going on. Secondly, LCANZI is now part of the ecosystem. So we had a number of people coming to us and saying, look, want you to know about this issue, want you to understand this background. Do you guys think that there's something in it? Is there a potential legal claim? So that's wonderful after 4 years of existence that we're seen as the body to go to bounce those things around with. And Jenny, special recognition for your role in creating us, and certainly very much looking forward to you returning to the fold after a few months' absence. Then thirdly, it was a case that was quite conveniently a discrete and quite patent failure, that the commission had said one thing, the minister had recommended the same thing, then Cabinet, based on some pretty skimpy advice from Treasury, had gone off in a different direction. So that meant that we could go forward with a single witness, Christina Hood, who is one of the top people in Aotearoa in climate science and climate policy, who's worked at the International Energy Agency in Paris, who's consulted to the Ministry for the Environment and various other entities. She had decided that she wanted to be able to act independently, so she has taken the risk of losing that government work She was available to us and did a huge amount of work in terms of refining the issues and preparing her own evidence so that that was ready at the same time the claim was filed. It also being a discrete issue, we weren't really balancing up any competing factors. There were no, unlike the Climate Change Commission judicial review, where we were concerned that the issue was a bit complicated and that we didn't want to dent the mana of the Commission, even though they'd made mistakes in the first round. We wanted them to still be a force going forward. Here it was all one-way traffic in terms of the strategy. The only thing to cause a bit of pause for thought was that one option was that the government had created so much uncertainty and distrust in the ETS that it was possible that all the auctions were going to fail this year. That would have had a real upside in terms of forcing the drawdown of units from the existing stockpile. So it would have been an extreme way of limiting the unit supply by having 4 failed auctions. But that seemed that it would be unlikely. It seemed that bidders would come back in at a sufficient level, and also it would leave the ETS in tatters at the end of that process. So it caused a bit of pause for thought, but those were the balancing factors there. Then fourthly, the way it all came out was that there was a lot of common interest by all the players involved by the end of the process. So the minister, we were essentially saying that the minister was right, and the problem was that Cabinet had disagreed with him and the Commission. So the minister who we were reviewing was on our side. The Treasury Minister of Finance angle, which I think had been saying, look, this will have a cost of living implication, so we want to not pull back too hard on the unit supply. That faction had the experience of losing $1 billion of auction revenues in the first 2 auctions compared to what had been expected. So I think Cabinet had a real fiscal and learning experience to come in behind us. The Crown Law Office lawyers were fantastic. They said, upfront from their initial analysis that they could see the problems in the decision making. And also, obviously, the Climate Change Commission, although not directly involved in the litigation, were very aligned in terms of the appropriate outcome here. So that was partly happenstance, but I think also it reflects the approach we took, which was not to rub problems in anyone's faces and to build a golden bridge for the minister to retreat back over. We didn't go for the grounds of review, which might have been the most embarrassing in terms of claiming that he acted under dictation of Cabinet or that the decision was incoherent. Both of those were plausible grounds, but we were happy to settle with an admission based on a more vanilla process failure. So I think that was obviously in any judicial review, it's ideal if the person you're reviewing has changed their mind in the meantime. But I think also being constructive in your approach and not making it hard for people to back down is also a learning from it. Fifthly, the court really played its role. So it was a relatively, although the headline version of the case is quite straightforward, there is quite a bit of detail there, and we had quite a long agreed statement of fact and a joint memorandum which explained the legal framework and suggested that the judge might want to pick that up in the judgment. And the judge, Justice Palmer, called a conference of the parties much quicker than we'd expected. I was on holiday, so I had to get the leave of the court to appear in a Hawaiian shirt. Then he had already done his cutting and pasting and his own analysis, so that the decision was ready to go out that day. And then obviously Cabinet also acted with real efficiency in reconsidering the issue. So that all contributed to a fantastically efficient timeframe. Then sixthly, I just wanted to acknowledge the team. Monique Van Alphen-Fyfe from my chambers did a fantastic job. Gilbert Walker, who have supported us in this litigation and also in the Climate Change Commission judicial review. they give us the Rolls-Royce treatment. We are treated as if we are a first-class passenger, even though we're actually flying standby and not paying. And Martin Smith and Rebecca De Silva did a fantastic job, really turning around a few scrappy notes into a polished draft statement of claim over a weekend, and you can't ask for better than that. Christina Hood is a fantastic climate policy person, a fantastic scientist, and it was just so much fun to have her horsepower working with us. So really appreciate that. But also the board for its support for taking the case, where our track record, although we won a lot on the substance of the first judicial review, it wasn't ultimately successful in terms of the legal outcome, or at least at round one. We're back in the Court of Appeal in November. But the board were unfailing in its support of bringing the proceedings. And also, for people that haven't been on our board yet, I'd encourage you to do it, because it's a fantastic ethos where even though things were moving very quickly, people put their hand up to help with the media statements or to get the social media out and to generally keep everything running. And even though we can probably fine-tune our work on large-scale video conferencing in terms of the bread and butter stuff of climate litigation, it's just a wonderful group of people to work with. So those are my reflections.